All right, the next case is Stasinos versus Department of Business and Professional Regulations, case number 15-2506. Both sides have 15 minutes. I want to make sure the appellees are, the appellant is aware that the appellees have agreed to split their time 10 minutes and 5 minutes. So, you may proceed.
Good morning, Your Honors. Frank Brady and Jeannie Brady on behalf of the appellant, Chris Stasinos. We're here today on a issue of the applicability of a statute of limitations, or the length of the statute of limitations in a claim that is filed under the Florida Homeowner Construction Recovery Fund. As a chronological matter, this is a contract to improve or build the claimant's home, signed August 29, 2005. A civil lawsuit was filed against the contractor January 3rd, 2008. And then the contractor, this Andover Construction Inc., which is the company through which the licensee did his construction contracting. The Andover filed bankruptcy in August of 2008. The plaintiffs who filed the civil lawsuit then moved the bankruptcy court for relief from the bankruptcy stay. In June of 2009, the bankruptcy court granted the motion to lift the bankruptcy stay June 29, 2009. Then a final judgment in the civil action was rendered July 29, 2010. However, the statement of claim that was filed to recover funds was not filed with the state until July 31, 2012. And our statute says that the statement of claim has to be filed within 1 year of the issuance of the final judgment in a civil action. It also talks about an administrative action or an arbitration award.
Right.
Now,
So let me ask, because your contention is the trial court erred because the board decided that the statute of limitations should begin to run when the bankruptcy proceeding was over with, rather than the final judgment.
correct.
And you're contending that they've interpreted the provisions incorrectly.
That's correct.
Let me just ask this. Florida Statute 489.141 says a claimant is eligible to seek recovery from the recovery fund after making a claim, et cetera, and then it continues on, if each of the following conditions is satisfied, and then there are 8 conditions listed, okay?
Right.
Condition E starts out, the contract was executed on or after July 1st of 1993, and then it goes on, and provided that under subsection 1, the claimant has caused a writ of execution to be issued, etc. And then under 2, if the claimant is unable to comply with subparagraph 1 for a valid reason, the claimant has made all reasonable searches and inquiries to ascertain whether the judgment debtor or licensee is possessed of real or personal property or other assets subject to being sold and applied in satisfaction of the judgment. So my understanding is the thrust of the statute is before you come and ask for recovery from the fund, you need to basically exhaust trying to obtain money from the other sources. Agree?
I disagree.
Okay.
And the reason is when you read through the statute, another one of the so-called conditions in subparagraph G is that they've applied the damages award that they receive from the court or the amount of restitution ordered by the board. So the board can't order restitution before you even file a claim. So I think that this provision that you're reading is one that they have to prove once they file the claim. And in the Free case that we cited, That one was one where the statute of limitations was 2 years, but it was based on whether when the violation, the contractor's violation occurred. And the second DCA said that the statute of limitations runs from the time that the violation occurs. And here, similarly, the statute itself, subparagraph F, talks about the statute of limitations starting when the civil judgment is rendered. So I think that a lot of these conditions are not conditions precedent to filing the suit, but conditions precedent to recovering the money from the fund. In other words, items of proof as opposed to when you have to file your claim.
Well, what the statute says, it doesn't say the claimant is eligible to obtain recovery, it says eligible to seek recovery. So it seems to me that the language says that in order, as a prerequisite to filing a claim for recovery or requesting a recovery, that these prerequisites have to be made.
I think that the subsection F is really a standalone statute of limitations, because that's the way, at least the second DCA interpreted it.
Counsel, if we just try to work through the text of 49.141, it's entitled Conditions for Recovery and Eligibility, and it says, and I'm going to read in part, but hopefully as necessary, any claimant is eligible to seek recovery from the fund after having made a claim and exhausting, and then it lists any limits of any available bond, cash bond, surety, guarantee, warranty, letter of credit, or policy of insurance. It seems that your client did all of that because either they did it or they were not, it was not applicable. So you have that. And then provided that each of the following conditions is satisfied, and the main one seems to be, as I think you just pointed out, F, a claim for recovery is made within 1 year after conclusion of any civil, criminal, or administrative action. So the question I would like you to focus on F, as you started to do, and tell me whether, I assume obviously you're saying that the money judgment, the $75,000 or so, was a civil judgment.
Yes.
But is the bankruptcy action, is that an administrative action, if we were to consider it, or a civil action? What is it? What is it in the law?
Bankruptcy, the bankruptcy statute is a federal statute, of course. And it's not a civil action based on the claim. Based on the act. A bankruptcy is a federal procedure to discharge debts. The statute here, first of all...
Based on the act, are you referring to, you're obviously referring to this act.
I think that's what the legislature meant, based on this act. Alternatively, they may have meant the act that constitutes the violation of the licensee's duties. But again, I go to that first sentence
I'm troubled, I think, by F. It says, each of the following conditions, a claim for recovery is made within 1 year after the conclusion of any civil, criminal, or administrative action. I understand your position that it's within 1 year of the judgment, the circuit court judgment. But let's assume that's not so. What's the bankruptcy action? How does it fit into F?
Let me answer it this way. Two things. Number one, the very first paragraph, this subsection 1, talks about after having filed a claim, that all of this happens.
Right.
Number two, to address your specific question, which is what the position of the appellees are, bankruptcy is not an administrative action based on this act. The bankruptcy is a federal action to discharge debts. And this act is a state act as to how one who feels aggrieved by a construction contractor failing to perform their contract should be held liable for it. So they had to file a claim as the first sentence of this statute states, and then all of these other things happen.
So I want to go back to subparagraph E, though, because you're contending that because my understanding is whenever a claim is made, the licensee is always noticed, right?
Whenever, yes.
Okay, and the licensee is allowed to show up at the hearing in front of the board to decide whether or not the award should be given.
Yes.
Your client is allowed to contest the award, right?
Right.
Okay. So you're telling me that if your client showed up and traveled on subparagraph E and said, it's not appropriate for you to grant an award because the claimants have not demonstrated that they have tried to collect assets against Andover. You're saying that that would not be a valid defense to whether or not the claim should be paid because they're not eligible because they haven't complied with paragraph E.
Well, I'm saying that there's certain things in these cases on this statute that the board can waive.
Well, but my point is, it strikes me that compliance with paragraph E is a requirement to be eligible to file a claim. So it kind of strikes me that it's in the nature of a condition preceding. And if that is the case, then the problem becomes if you can't do anything to collect on the writ of execution or to try to go after any assets or property that Andover has because there is a bankruptcy proceeding, then it seems to me the claim has not ripened. And a statute of limitations can't begin to run until the claim ripens, it seems to me. So my concern is if subparagraph E is a requirement to make one eligible for filing or making a claim, then it seems to me the board got it right by considering the consequences of a bankruptcy which stymies the claimant from being able to comply with subparagraph E.
All right. Well, the problem that I have with that interpretation is that it essentially makes the statute of limitations evergreen because they can take, for example, their civil judgment could have been recorded and could be collected on for 20 years.
And one of the board members expressed concern about that in the hearing. But then when the board member found out, oh no, the bankruptcy was actually filed during the lawsuit where they were trying to collect against Andover, then that board member thought, well, okay, then that makes sense. But,
Well, it also says in this statute that the claim, the transaction giving rise to the claim is removed from the bankruptcy, and that's exactly what happened with this claimant. They removed the action from the bankruptcy by asking for relief from the stay, and then had expressed permission to pursue not only the civil judgment but to pursue their claim with the fund. And
but they weren't given permission by the bankruptcy court to try to levy on any assets of Andover. And without being able to levy on any assets, they can't comply with paragraph E.
well, they never did that. They got the discharge of the bankruptcy. They still didn't get permission to levy on the assets of the judgment debtor. And number two, the license holder, Mr. Stasinos, was never in bankruptcy. There was never any prohibition against pursuing him for the assets. So we think that yes, we'd like to reserve some time for rebuttal. Thank you.
Good morning. May it please the court? My name is Siobhan Christian, and I'm here on behalf of the appellees, the Department of Business and Professional Regulation, the Construction Industry Licensing Board. Mr. Teltman is here on behalf of the claimants, and he's going to take the opportunity to discuss with you all the timing regarding the statute of limitations and the bankruptcy.
Counsel, I'm sorry, I forgot to mention to you. As long as the light is green, you're in your 10 minutes. When it turns yellow, you are into the other appellee's time.
Yes, Your Honor. As I will explain, Mr. Stasinos has failed to demonstrate that there was any reversible error committed in the proceedings below. I'd like to start by addressing a little bit the Florida Homeowners Construction Recovery Fund. This court held in Shimkus that the Recovery Fund statute is clear. Section 489.1401 stated that the legislature intended that statute to compensate aggrieved homeowners who have obtained judgments in this state. In the third DCA, the Chappelle case held that the Recovery Fund is a remedial statute that should be construed liberally in favor of granting access to the remedy to achieve its legislative intended purpose. I wanted to speak briefly about the jurisdictional arguments put forth by the appellant. Like the first DCA's holding in Bayonet Point, this court held in Humana Incorporated versus the Department of Health and Rehabilitative Services that a court must affirm agency's decision unless it is arbitrary, capricious, or inconsistent with the Administrative Procedures Act. And this court went even further to hold that on an issue of agency discretion, that the reviewing court shall not substitute its judgment for that of an agency's. We would argue that the board's granting of a motion for rehearing in this matter was a discretionary decision based on the fact that there is no specific statute or rule authorizing motions for rehearing in administrative law, but based on the fact that there was a due process violation and concern in the underlying case against the claimants, that the board wanted to seek to be able to provide them relief, to be able to allow them the opportunity to meaningfully participate in the proceedings below.
If I recall the argument of opposing counsel correctly, they focused not on that, but rather on the statute of limitations issue.
Yes, Your Honor.
Would you focus on that for me, please?
Yes, sure. As I explained earlier, Mr. Tellentman will go into further detail about that. But as Judge Connor noted, it is our position that Section 489.141 sub 1E, the subsections within that 1 and 2, do clearly indicate that the claimants must seek all necessary action, is the language used within those subsections.
Well, you're here for the department,
Yes.
You're here for the department?
Yes.
Okay, I didn't quite pick it up at the beginning. I thought that's what you said. So, carry me through what the department has to say about subsections E and F of 489, or carry me through 489-141, and what the department's position is on that, because it seems to me that ought to be considered.
Yes, Your Honor. So the board has the discretion to be able to interpret its statutes and its rules, the ones in which they administer.
Let's get beyond that, okay?
Okay.
140, let's step through the statute.
Okay.
141, any claimant is eligible to seek recovery after having made a claim. This client made a claim, correct?
That's correct.
And exhausting the limits of any bond, cash bond, surety, guarantee, warranty, letter of credit, or policy of insurance. This client did all of that.
Right.
Okay. Provided that each of the following is satisfied, and I think we seem to be centering in on E and F. I was centering more on F, but is it your position that they did not satisfy E?
No, it's our position that the claimants did satisfy E1 and E2. Yes.
All right, so then we get down to F.
Right.
And it says a claim for recovery, the next thing they must demonstrate is, so far, so good for them. The next.
For the claimants, yes.
All right, then we get down to the last one. A claim for recovery is made within 1 year after the conclusion of any civil, criminal, or administrative action based upon the act. What is the act?
Well, based
What
on
is your position of the act? Just tell me what act we're talking about.
the act, we interpret that to be the act that occurred, the violation.
The violation. Okay, so then you folks found there was a violation. but it still has to be after the conclusion of any civil, criminal, or administrative action. And why is that not the judgment, the final judgment? Or is it the final judgment? What's your position on that?
Well, so there was a final judgment issued in this case, but pursuant to E1 and E2, they wanted to make sure that they pursued the opportunity to see whether or not they would receive a disbursement from the bankruptcy. So although there was a final judgment in this case, in order to satisfy that subsection of E, essentially the board related back to the statute of limitations time, to the conclusion of the bankruptcy proceeding. And upon the claimant's
Is the
discovery,
bankruptcy proceeding a civil, criminal, or administrative action?
the board made the interpretation that the bankruptcy action fits within the parameters of an administrative action.
And what is your authority for that?
We would argue that it's a discretionary,
There must be
application.
some authority out there concerning what a bankruptcy proceeding is. Is it a civil case? I mean, we know it's statutory
Right.
out of the United States Constitution. We know how all that works. But is it a civil matter or is it an administrative matter? Is it Chapter 7 an civil or administrative matter, and what is your authority?
Based on the board's interpretation of what an administrative action is, it found that a bankruptcy action fits within the parameters of an administrative action.
And what is your best authority for that, your best case?
Well, we would argue that the case law that regards the statutory interpretation by the board to administer these acts should be given great deference.
Well, I know you want me to give you a lot of deference, but let's say I don't want to.
Okay.
What is your best authority? What is your case? What authority do you have to argue, to tell me that's an administrative action?
Well, our argument is that it's based on their statutory interpretation,
Whose statutory
the
interpretation?
board's.
The board, all right. And what rule, case, or interpretive authority has the board issued, counsel, that you can tell me about and rely upon for what you just said?
Well,
Have any?
there is no case law substantiating such.
What you just said. There's no case law, rule, authority, opinion of the board substantiating what you just said, correct?
I mean, other than the opinion that's in their final order that was issued in
Okay,
this matter.
that's all you've got? Okay.
That's correct. We'd also like to address the issue of the bankruptcy as to Mr. Stasinos himself. Based on this court's holding in Shimkus, which is directly in line with the facts of this case, that primary qualifying agent agreed to be the primary qualifying agent for a company called Thompson Homes. Under that contract, he was to be advised if they were to involve themselves in any construction or financial activity. Based upon that, essentially Thompson Homes violated the contract that they had with the 9 home buyers, and in doing so, the appellant in Shimkus, the primary qualifying agent, was held it was held that his license is subject to suspension because he was the primary qualifying agent. And what's important in that case is that Mr. Shimkus, the appellant in that case, had no knowledge of the fact that Thompson Homes had engaged in contracting and financial activity, despite him being the primary qualifying agent. And we would argue that this court's holding in Shimkus is applicable to the factual circumstances in this case, because not only was Mr. Stasinos aware of the contract, but he engaged the claimants in their contract. Furthermore, he had signed each of the pages of the contract. He signed the last page of the contract. His general contractor's license number was at the header of the contract. And so we would argue that Mr. Stasinos' license is subject to suspension, as Mr. Shimkus's was in this court's holding. So we would ask that this court affirm the board's final order granting the claimants access to the recovery fund.
Good morning, Your Honors. Jim Telemann. I'm here today representing Mr. and Mrs. Gazzetta. Seems I'll be doing some cleanup work here, as I think you've probably covered much of what I was going to present in your questioning of both Mr. Brady and my colleague for the state. But to get to your question, Your Honor, is there a case out there that takes a bankruptcy proceeding and places it somewhere within the statutory framework of 489.141?
F we're looking at.
Anywhere.
Well, we're looking at F. Let's say we're
F in
looking at F
particular.
here. All right, so my question is, just to follow up,
Sure.
you agree with the department, that I gather, that a bankruptcy action is an administrative action, correct?
Or a civil action.
Or a civil action, and is there any case law anywhere in the country that helps us decide whether it's a civil action or an administrative action or both? Anything that you have?
As to that specific narrow issue, I'd have to say, to my knowledge, the answer is no.
Okay.
However,
You've looked, I
I've
assume.
looked.
You've looked, all
You
right,
bet.
that's fine.
There is the Chappell case, Your Honor. And what the Chappell case provides, and I know this is far more general than what you're asking me about, but it does provide that this statute should be construed liberally in order to provide relief
All right.
to a complaining homeowner.
Let me come at it from a little bit different direction. Am I correctly understanding that the claim in bankruptcy included issues about whether Andover breached a contract with your clients and caused them harm? Was not the issue about, that was the basis for the claim in bankruptcy court, was it not based on the act
Of course.
that Andover and Stasinos dropped the ball in terms of constructing the house?
Yes, Your Honor. I mean,
Okay.
that was the relationship between the parties.
Okay. And I think what I recall, although I never practiced in federal court, but I think I recall that the bankruptcy court is part of the judicial branch of the United States government.
I think that's safe to say.
And to the extent that they control the process where creditors are seeking relief from debtors, it certainly strikes me that that is a civil proceeding. So it strikes me that if the claim in bankruptcy dealt with the fact that the licensee in Andover breached the contract, and that's why they're in the bankruptcy court trying to obtain money because of that, it certainly seems to me that we're talking about a civil proceeding based on the act, aren't we?
I totally agree, Your Honor. And to make an even clearer example, using a hypothetical. And the one thing about my friend Mr. Brady's argument that bothers me the most is essentially what I hear them saying, and maybe I'm wrong, is that we shouldn't even think about bankruptcy in the context of this statute because it's not mentioned anywhere. But think of a situation where, make it as clean as you want to make it, somebody gets a judgment on day one. And they have 365 days, if we accept their argument, to file a claim or we're forever barred. And on the 364th day, the contractor files for bankruptcy protection. What do you do? You can't get instantaneous stay relief to pursue your claim with the Construction Industry Licensing Board. You have to wait it out. Let's say it takes 6 months to get stay relief. Are you forever barred from seeking recovery in front of the CILB?
Who made the claim in this case? It was his client made the claim against the fund, right?
No, sir. No, sir. My client.
Your client, I'm sorry, yes,
Yes, sir.
okay.
He
I'm sorry.
represents the contractor.
That's correct.
the
That's,
homeowner.
Or actually the
that's-
licensee.
okay,
The homeowner
all right,
made the
all right.
claim.
Yes, sir.
Sorry,
Yes, sir.
sorry about that.
So if we're going to construe the statute liberally,
Did your client also make a claim against Stasinos?
Stasinos. No, sir.
You
But
just
that's-
made a claim against Andover, that was the right party.
Well, they were the contracting
They were,
party. They were the contractor that we dealt with. We had no contract with Stasinos. And as the Shimkus and Murthy cases tell us, to have sued Stasinos would have been unauthorized.
Okay.
We had no direct claim against Stasinos. Yet Stasinos' license is still in play, if you will, and of course, that's why he's here. I also take issue with this whole statute of limitations notion and the appellant citation of the Free case. The Free case dealt with a prior version of the statute, which was a classic statute of limitations, where the prior version of the statute said a claimant had 2 years from the date that the cause of action arose within which to file a claim with the Construction Industry Licensing Board. That statute doesn't exist anymore. To rely on that case as applied to the situation in this case, I think would be a mistake. I see I'm already over my time. Essentially, I think, as Judge Connor said at the very beginning, we have 8 requirements of equal weight that a claimant has to fulfill in order to be eligible for recovery from the fund. The board concluded that all 8 were fulfilled. None is more important than the other. And I think that to ignore the requirement that all efforts to liquidate assets from the contractor be exhausted prior to coming to the board for relief is as important as any other element and should be given the appropriate weight. I also think to ignore the bankruptcy process because of no one's going to place this statute in the Statutory Drafting Hall of Fame, I don't think, up on a big pedestal, but I don't think it's a stretch to conclude that a bankruptcy is in fact either a civil or administrative action which must be considered when the facts present themselves such that it must be considered. And I think that our clients filed within the requisite time. I ask that you affirm the decision of the board, and absent any other questions, thank you very much.
A couple of quick points. Again, I focus on the language of the very first provision of 489-141, which says, after having made a claim. You have to read every part of the statute, not distinguish or ignore parts of the statute. So, and in the Free case, I think it does apply because all of these other conditions that are in this statute about having to satisfy your execution and your attempt to recovery were in existence in the version of the statute that was in existence with the Free case. They didn't eliminate or add all of these other conditions after the Free case. The only thing that they changed was when your statute of limitations began to run, whether it was based on the violation of the statute or issuance of the judgment. So I think that the Free case does apply. And the claimants elected their remedies here. They pursued a state court action. And as far as the bankruptcy being, I don't think it's an administrative action at all. It is.
So why isn't it a civil action based on the act?
Because, well, it is, first of all, that 28 U.S.C. 157 talks about whether it's core or non-core. Core meaning that the bankruptcy judge of bankruptcy court has a judicial authority to adjudicate everything. And the relief,
Bankruptcy judges are not Article III judges.
they're not Article 3, but they don't have to report to the Article 3 judge in a core proceeding, whereas if it was non-core, they would have to send a report and recommendation for the Article 3 judge to rule. And that's the analogous situation to administrative in our court system. So I think that the disjunctive part of subsection F, it's either a civil action or an administrative action or a criminal action or an arbitration award. In this case, the civil action is the one that was filed in the circuit court, and that's where the judgment was rendered.
I'm still trying to figure out why wouldn't a bankruptcy proceeding fall under the rubric of being a civil action?
It wouldn't here because they took it out of bankruptcy. They requested relief from the bankruptcy court to take it out of bankruptcy and pursue it in state court and pursue it at the agency. And the bankruptcy court granted that relief. So it expressly
So
took it.
paragraph E then is superfluous as far as, it doesn't apply here, is what you're
No,
saying.
I'm not saying it doesn't apply. I'm saying that when you read the first sentence of the statute, after having made a claim, and then you do subparagraph E. They hadn't made a claim. They never made the claim until a year late. So after having filed the claim, they were supposed to do subparagraph E. They didn't file the claim first and then do subparagraph E. So I ask the court to reverse the administrative body. Thank you very much.
All right, thank you. Court is adjourned.